Good morning, everyone, and welcome to the ODPP Café. My name is Anita Onuko. I'm your host for the show. This is a show brought to you by the Office of the Director of Public Prosecution. We are live on Facebook and on YouTube. The show is aimed at imparting knowledge on you to tell you what to do either when in contact with the law or in conflict with the law. We talk about the criminal justice system, a lot of the times from the ODPP perspective. The show, like I said, is live, and you're invited to engage with us on Facebook and on YouTube. You can also subscribe to the Office of the Director of Public Prosecution page on YouTube, and also follow us on Facebook and on Twitter. On Twitter, we are at ODPP_KE, and on Facebook, like you're seeing right now, we are at the Office of the Director of Public Prosecution. So welcome and feel free to engage. We are still on the topic of hate speech, and I have on studio two experts on the topic of hate speech. But as always, before I start, I'm going to take you through a quick sneak into the courts and some of the activities that have been taking place at the ODPP. So I'll start with the courts this morning, rather just for now, but this one was reported yesterday, that the Monica Kimani murder trial is on. The hearing of the Monica Kimani murder trial continued with prosecution witness Chief Inspector Eshwari Njoki taking the stand to testify. The Chief Inspector, who was then attached to Langata Police Station and who investigated the shooting incident, testified that the suspect, Joey, shot himself. So earlier, we heard about Dominic Bisera, the security guard, whose ID was found at Lamuria Gardens, where the murder took place, where Monica actually lived, having been booked as her visitor. He took the stand to just talk about that. Bisera told the court that he had lost his ID at Langata's Royal Park Estate, where he had gone to work as one of the casuals at a construction site. So the prosecution pointed to the possibility of Joey having picked the ID from Royal Gate, where Maribe lived. So 7 more witnesses are expected to testify on this case. So that's the Monica Kimani murder trial that is ongoing. The next story is a bizarre story of a man in Kirinyaga who was charged with killing his wife and kids. The 35-year-old man was arraigned in Kerugoya High Court and charged with the murder of his wife and 4 kids. The prosecution submitted that on November 28, 2021, Paul Murage hacked to death his wife, Millicent Mudhoni, and his children, Nelly Wawira, Gifton Bundi, Clifton Njuki, and Shelmith Wamboi. So that he was arraigned in court in Kerugoya to answer to these charges. So Murage denied all 5 counts of murder. The prosecution, through Vincent Mamba, objected the accused plea to be released on bail. The case to continue on February 28th. We've talked about bail on the show, and we say that it comes with some responsibility and sometimes conditions. And in being denied bail, the court must have seen some conditions that were unfit for him to be released on bail. So the case continues. The other case is about a man who was charged with robbery with violence. He was accused of stealing mobile phones and some cash from 3 city men. The guy was sentenced to death. Sorry about that. So Michael Odhiambo was convicted by Kibera Senior Principal Magistrate Philip Mutua after the prosecution proved the case against him. So this guy stole phones, 3 phones from 3 people, and he's found himself on the wrong side of the law, actually sentenced to death because of that. So Mr. Odhiambo was found to have robbed Peter Kenyatta of 5,000 and a mobile phone worth 14,000 on December 30th, 2015, and also robbed John Karani and Peter Gishohi of different amounts of money and mobile phones on the same date. He has 14 days to appeal. Again, we talked about appeal. It's his right to appeal in as much as the court has made its judgment, pronounced its judgment. I hope I got the legal term right. So the other one is about activities at the ODPP. The DPP, Nurdin Haji, met with IDLO Country Director, Horn of Africa, Adam Shirwa Juma, and Country Manager Kenya, Teresa Mugadza, where there were discussions on areas of cooperation on regional and transnational organized crime. You cannot win transnational and organized crime without a multi-sectoral approach and, of course, working with other IGOs like IDLO. So IDLO is International Development Law Organization. It's a global intergovernmental organization devoted to promoting the rule of law, to advance peace and sustainable development. So this is quite important, especially in the criminal sector, where you have to work together to achieve desired results or outcomes. And The other one was a sensitization that is going on in the North Rift, in Eldoret especially. The ODPP conducted sensitizations on plea bargain and diversion policies in Eldoret town, targeting prosecutors, government agencies, media, NGOs, CSOs, and the public. The ODPP, in collaboration with UNODC, has conducted similar sensitizations in Wajir and Garissa counties, Coast, Nairobi, and Nyanza. Again, we've talked about plea bargain here, we've talked about diversion policies here, and I'm looking forward to discussing the same again this year with you so that you get to learn what these things mean. And of course, we'll have experts to discuss the same with you. So these policies, plea bargain and diversion policies, are aimed at reducing case backlog and decongesting prisons, amongst others. So it's quite an important, they're quite important policies that make work easy in the criminal justice sector. So once again, I thank you for joining us. We are live on Facebook. Please invite your friends to like our page and follow our page for more information and other stories about the criminal justice sector and information, of course. We say knowledge is power, and when you listen to what goes on in the show and the discussions on the show, then you learn something. I keep learning a new thing every other day, and I'm inviting you to actually listen and learn, and you'll know what to do when something happens to you or someone close to you. Like I said earlier, we are on Twitter at ODPP_KE. Again, you're welcome to engage. You can ask questions. You'll get responses. And you can also even slide into the DM on Facebook and on Twitter, and you'll get assistance. On YouTube, we welcome you to subscribe and follow the channel, Office of the Director of Public Prosecution, to watch more videos. Last year, we did about 40 videos, and we are still going on. There's so much to talk about. And of course, you can repeat some topics if you want. You can ask us to repeat some topics, or we can bring guests onto the show to discuss some of the topics that you may want us to discuss. So this year is election year. The campaign drums are beating louder and louder as the days go closer. And you can imagine it's, I think, 6 months to elections. And it feels like elections are next week because the drums are louder and louder. So a lot is going on. But for the sake of this discussion, we want to talk about hate speech. So we want to look at hate speech and the different facets of it from an ODPP perspective. And of course, we'll invite other experts on the show like we did last week. But again, still on electoral justice and hate speech. So today, I have guests on the show. You've seen them before, you've met them before. But I want to allow them to introduce themselves, to just again tell us why they are here, and then we can get on with the discussion. I will start with the beautiful lady. Right. Karibu sana Jacinta, please introduce.
Good morning, Anita.
Yes.
And good morning, viewers.
Yeah.
My name is Jacinta Nyamosi. I am the head of the Conventional and Related Crimes Department. Election and hate speech offenses fall practically in our department. And we're here to demystify what hate speech is and election violence. Electoral offenses. Reason being that people out there see videos running on Twitter, running on Facebook, and they assume that's evidence. We need to explain to everyone what evidence and how we are getting to the courts of law. Okay. So we are here to break it down, make it easy for each and everybody to understand.
Okay.
Yes.
Pleasure having you on the show once again.
Karibu
sana. Looking forward to you teaching us. Mark, you can only introduce yourself in Kiswahili.
Asante sana Bi Anita kwa kutukaribisha katika studio. Kwa majina naitwa Mark Barasa. Nafanya kazi katika ofisi ya mkurugenzi wa mashtaka ya umma. Kwa hivyo kwa ufupi nahusika na hate speech and election justice katika division ya hate speech and election justice. The hate speech and election justice division is under the conventional and related crimes department. And the head of that department is here with us today. Okay. So it's a good day to have her in the studio as well. All right. So thank you very much for welcoming us.
Karibu sana. Hate speech kwa Kiswahili ni?
Semi za chuki.
Semi za chuki.
Semi za chuki.
Umetuweza na Kiswahili. Some of us can't, not that we don't know, but sure. I respect that you are
translating.
Yeah. So, Madam Jacinta, just tell us, there is a legal framework in this hate speech.
Yes.
Yeah. What is it? How do you bring it out for us?
All right. There are various pieces of legislation which can be used in relation to election and hate speech offenses. Of course, the Constitution, we start off with the Constitution, Article 33, we have the freedom for expression,
Yes.
but that freedom is curtailed when you are going to encroach into somebody else's right. So when you've encroached into somebody else's rights, then we are going to look at the legal framework. We have the penal code, we have the National Cohesion and Integration and Cohesion Act, we have the maybe if you can remind me, Mark, the other one.
The Election Offences
The
Act.
Election
Election
Offences
Offences
Act, yeah.
Yes.
Yeah.
So we have the pieces of legislations, they are in place.
Yes.
And these are the kind of laws we are going to use when you have infringed Article 33 of the Constitution.
Sure.
That is when you go overboard in your freedom of expression.
Yes, when you go overboard, and we must be very, very clear. There is, we have to look at freedom of expression,
Yes.
and when you have contravened, when it comes out to talk about hatred, or when you are out to kind of inflame the public to do something wrong, you are creating a lot of disturbance. We are looking at that kind of scenario. Yes.
Are there terms, I mean, from past elections, are there those things we've learned that when somebody says, then they're fanning hate? Are there those words that tick you off and say this one is fanning hate? Do we have them, or it's just as we go, we know you figure it out?
Experience has it that, and because some of these words are already being used by various political persons, we might not want to dig into it, but we know that there are some terms which were used. And when you look at it, we look at those terms in context where they were said, who was saying them, why they were saying them, and who they were actually intending to show or talk about. Because if you talk about a certain group of people and you are referring to them in a certain word, we are able to identify that vis-a-vis. Why were you talking about this? Why were you saying this? So and so, let's say if you are calling these people sanitizer, for instance, you've called them sanitizer. We know they are, we want to know, why have you called them this? Who are they? And why are you not putting them in your group or where you live? Is this an area where, for instance, let's say if I talk of Kisii, let me give my home area so that I don't look like I'm pinpointing on a particular region. If I say sanitizer watolewe, that means anybody else who is not a Kisii is not welcome. I mean, I'm just using a word.
Yes.
So why are we removing this particular, why are we inflaming the community to believe that these people are not part and parcel of that community? So that is what we need to understand, that yes, there are words, but you'll have to put it in it has to be global.
Yes.
You don't look at the word itself, but in the context in which it was made.
It was used.
Who was the it made, and who said it, and why they said it.
With all these laws, why are we still struggling with hate speech as a country? Is it our values as a people?
Let's put it this way. I think we need to continue talking to our people, explain to them that we all belong, and the reason why possibly this has been a problem to a certain extent is that people talk about there, especially in the social media.
Yes.
And in the social media, people assume that they can say anything. But these kind of utterances that they make out there, whether it's in the social media or even in public, must be able to be picked in such a way that it's palatable and it can be able to be presented as evidence. And palatable, I mean that it's not that video outside there. They are the rules of evidence which must be respected and followed. So if we don't follow this, then we'll be letting these people who have uttered these very sensitive issues or words or incite people, we'll let them walk if we are not careful on how we are collecting this kind of information or the things they are talking about in public.
Okay.
Yes.
So under the legal framework, Madam, there's the Sexual Offences Act. How does this play out in the election period? And why is it under the hate speech legal framework? And electoral offences.
And electoral offences. It is very sad and very unfortunate that sexual violence has actually been used as a tool of violence in itself. And research has shown that when, and you have to look at the situations that during elections or during that period when there is violence, some of this sexual violence is committed within a house setup. A man has to see what is happening to his wife, his children. You can imagine that man is completely finished. He is completely dehumanized by even seeing what is happening. So it has been seen, and research will bear us out, that sexual violence is used to dehumanize and to actually finish the egos of the people of that area. It makes people just keep quiet, shut out, and from talking about the things. So sexual violence must be looked at keenly, in that when election violence comes in, there has to be a space where we are going to protect, particularly women and children who have really greatly been affected. So you cannot remove election violence and sexual violence. It is actually one of the main tools. We have seen other tools like people being, for instance, situations of FGM being used on men, for instance, or women during that period. So it is one of the tools, but it has been seen as one of the most dehumanizing ways of making a society completely vulnerable. Yes.
So this addresses of like under Sexual Offences Act, when somebody says they sort of talk about a woman, you know, in a sexual manner, a woman who's campaigning, for example. Is there any law that protects women who are running for office from such utterances from people? You know, like I'd stand up and run for office and someone tells you, weka chini, you're a woman, you're not married, you know, those things that make you shut down. Are there laws that sort of protect us, or an offense has to take place, an actual offense has to take place for this to come into effect?
Yes, thank you, Anita. Laws are there, especially in the context of elections. When people are campaigning, there's a code of conduct which has been formulated by the IEBC, and all candidates must adhere to that code of conduct. It is actually a criminal offense under the Election Offences Act to violate or to infringe that code of conduct that has to be signed by all candidates and the political parties. So that kind of conduct during campaigns is not allowed. And the Office of the Registrar of Political Parties needs to look out for such offensive conduct. The IEBC needs to look out for such offensive conduct, so that those people who engage in such conduct, if they are found to be culpable, the sanctions should be imposed upon them, and they should be very strict, including barring that person from even holding political office. Equally, the Leadership and Integrity Act, the Public Officer Ethics Act, the Constitution itself. So there are various codes of conduct which we ascribe to for public servants, for other candidates who are not public servants. So under Chapter 6, the Ethics and Anti-Corruption Commission is also a key stakeholder. If someone is engaging in such conduct, they should be able to even take action against such a person, and even look for ways of barring him, because he is not fit to be a leader. He should not even be vying for elections in the first place. So under that under that provision, this person fails the leadership and integrity. So laws are there to protect vulnerable groups like women, the
and
people
living with disabilities. Exactly. I feel like saying at every point the law is very clear. The law is very clear, but clearly it's not. So Madam, just take us through the criminal justice system. Does it change during elections? Is it the same? Are the actors the same? And what's the mandate of the actors in this system?
It has not changed, for sure. Definitely when an offense has been committed, we have the investigative agencies going to the ground, collecting the evidence, presenting it in the best way, and so that we can be able to use it. So the investigative agencies have their role. And we are talking of, in this case, we have NCIC, we have IBC. They have their role.
Now they are the new...
yes, they are the new, they are, when we are talking of election and hate, we have to bring those institutions. But they don't work in isolation, because we have the DCI, we have the NPS. They all work together and be able to collect the evidence. Of course, we have the experts within the police to assist this. Then when they have collected the evidence, they must come to us as Office of the DPP, we give them an advisory. We look at the evidence, we establish, is the evidence admissible, credible? Is it something which can be presented in a court of law? The rules of evidence must be followed. So that part is done by the investigating agencies. So when it comes to us as the Office of the DPP, we look at a file and establish if there's sufficient evidence before we can make a decision whether to charge or not to charge. And if we are not, if we are able to look at the file and establish that the evidence is not sufficient, and it's evidence which can be found, we offer the advisory role. We direct the NPS, the DCI, other investigative agencies to cover ABC, so that the relevant areas that need to be covered before they can be able to bring the file back for us to make a decision. So our role will be to prosecute the cases after we have established that there's sufficient evidence and we have made a decision to charge. We present that evidence in the proper manner within the rules of evidence. Then the courts of courts adjudicate and they appreciate the evidence which has been presented. So for us is to ensure that what we are presenting to court is something which is going to be palatable and acceptable as evidence within the evidence, the law of evidence. So that is the role. There's nothing which has changed. It's just that we have all these parties together. And when they come together, and sometimes it's not that when we are working together jointly, we are entering into anybody's space. We are just strengthening ourselves, especially when we are talking about the investigative agencies and the Office of the DPP. We must work together so that we know where our weaknesses are. This hasn't been done, so you talk to the investigative, the investigators. In fact, on the ground, you'll note that even we have the 47 focal points. So you know that out there, even what is being done in Nairobi is also being done in the counties. So that's our strength, and we have agreed that in all spaces, the counties, we have that kind of multi-sectoral approach.
Okay, so I think the DPP at some point in this year has given directions for some investigations to be done. So at what point does the DPP direct that investigations be done? Is it that, maybe the question is, can the members of public reach out the DPP first, then investigations are?
Yes, Article 157 allows for the DPP to direct investigative agencies. At times we even pick up cases from the social media, or somebody just writes to us, or if I got to, somebody calls one of the prosecutors, you know, sometimes it doesn't matter. Information has reached us. Whether we are the investigative agency or not, we must have that information processed by them. So the DPP will direct the NPS or any other to investigate. So we can get into that space at any point. But of course, also the most normal way is when a report has been made at a police station or within any other investigative agency, then we can deal with the issue of advisory at that point.
All right. So he can direct an investigation to be done on a possible hate speech case, and then now it goes back to start from the beginning again. Where now the investigative agencies take over, and now they come back to you with the file.
With the file, for us to peruse the file and ensure that the evidence is properly collected.
And I think just for the sake of the public, it's also just very important to say that you can receive a file that doesn't have enough evidence, and it's within your right again as ODPP to return it to the investigative agencies to fill in the blanks.
That's
standard.
That is standard.
Okay.
That we are not saying that evidence is poorly collected per se, but there are times you find that maybe the investigative agency did not know that this is a legal, requirement. So when they bring the file with some of the gaps, we are able to direct again the investigative agencies. Please, this must be covered for us to be able to have this case, or for us to make the decision to charge, which is the mandate of the DPP.
Is there an acceptable duration for these hate speech cases? Is there a timeline that should be applied? Like, if you pick a case today, when do you want to see it? Do you have a vision as to when you want it completed? Is there an expectation of when you want it Yeah.
Yes, there is an expectation, since this is a serious crime that affects the public, especially in a multi-ethnic community like Kenya, which is prone and vulnerable to violence, including even genocide. So if we don't take care of these small crimes like hate speech, they can lead to bigger crimes where we have international crimes against humanity. So we need to take care of it, and therefore one of the ways of ensuring that justice is done is by having the cases speedily disposed of in court. So we are, the DPP has been on record asking the judiciary through the National Council on Administration of Justice to have special magistrates, especially during this election period, to hear these cases. And the judiciary is actually empowered by law to designate special magistrates and gazette them for purposes of election offenses. So we are hoping that these mechanisms will be put in place by our stakeholders, the judiciary, to ensure that these cases are actually expedited and they are disposed of very expeditiously, so that justice can be done. So that is what we envision, that is what we hope for, that our stakeholders, because we do not determine how the court's diary.
No, you can't.
We can't. But we have the DPP has been on record imploring the judiciary, the Chief Justice, to have special magistrates put in place so that these cases can be heard as quickly as possible and disposed of, if possible, within even a year. Yes.
That would be very interesting.
And maybe just to add on to that, that is when the matter has already been processed. But at the investigative stage, we would also want to have this case processed very quickly in court. And that is the reason why we are saying now that collaborative framework will make it so much easier, so that when we are speaking from the same table, we know this is ready and we move. And that will fasten even investigations, prosecution, kind of guided so that way we are better.
Prosecution guided investigations.
Prosecution guided investigations.
Okay, quite interesting. So the election process is quite long. There is voter registration, party primaries, vetting of candidates and clearing of aspirants, campaigning and electioneering, voting, declaration of results, post-election process. You're involved, you are alert at every stage, right? As ODPP. So my question is, at voter registration, what should I, Anita, as a member of the public be clear about? I mean, at what point at the voter registration will I get, for example, in conflict with the law? What will make you, ODPP, interested in me at the voter registration stage?
Well, as you rightfully put it, the election cycle is normally continuous. We have the pre-election phase, we have the election phase, and we have the post-election phase. So in the pre-election phase, you have those activities like voter registration, inspection of the voter register, procurement of materials to be used during electioneering period. So for voter registration, the members of the public should simply walk into the IEBC centers and register as voters. And we are imploring them to register as voters because their vote is very important in a democracy. The legitimacy of government actually is derived from the democratic will of the people. And therefore, during voter registration, members of the public should avoid maybe registering themselves twice. You register yourself here in Nairobi, then
that's
you want
a criminal offense.
Yes, you want to go and pretend that you are not the one who registered. You are somebody else. You want to register again twice. So such activities.
And I remember the IBC, Mr. Uye said last time that because of biometrics, that will not be possible. But of course, people who know how to
they want to
go around
engage in some funny behaviors. So it's not good. The IEBC also is on the lookout. Equally, members of staff of the IEBC, they should ensure that they do the right thing. They should not register people twice or engage in malpractices. So they should just abide by the law. And even the DPP is also on the lookout for issues of procurement of materials. The procurement should be done in accordance with the Public Financial Management Act and also in accordance with laws on asset disposal and public procurement. So everything should be done above board so that our elections should be just, free and fair. And then we'll come to the election phase when now we'll be engaging in the election and voting itself. So we should avoid intimidation, use of violence. Such acts are criminalized under the Election Offences Act. So we should just vote, vote cheerfully. We don't need to fight each other.
There's a time Steve Ogola said we need to look forward to elections like we look forward to Christmas.
Yes,
Are you ever seeing that day coming?
We hope for that day. It should not be kivumbi. It should be a time to celebrate. We are coming together. It should not be kivumbi. You just vote one day. The next day we live together again as Kenyans. And then post-election phase, we'll be looking at the criminal offenses which have been committed. We have prepared ourselves adequately. So anybody who engages in criminal offenses during election period, whether you are a candidate, you need to be very careful, because this year, it's the second time we are going to use the Election Offences Act. It was formulated in 2016. We partly used it in 2017 elections. But this year now we are 5 years down the line, so we have studied it, we have trained our counsel, we are very well prepared, we have formulated guidelines, and most of our prosecution counsel are just, itching for
what stands out
action.
in the election, in that act? What stands out?
In the Election Offences Act, it articulates around 17 election offenses. Yes, around 17 election offenses. And we are not just going to look at the Election Offences Act. Just as my boss, Madam Jacinta, has said, we are also looking at other legislation. If sexual violence is committed within the context of an election, we are not going to charge that person with an election offense. We are actually going to charge that person under the Sexual Offences Act. Yes. If fraud is committed, bribery, voter bribery, we will go for you using the Bribery Act, which has got more punitive measures. So we are looking tuko rada sana.
I hope so. So when we talk about ODPP's preparedness for election, and you're the Ministers of Justice, right, Madam? So what is the role of ODPP in safeguarding electoral integrity? What should we look out for from the ODPP? Because right now what you have seen is prosecution-led investigations. But beyond that, what should we look out for from ODPP in terms of your preparedness?
Technically, the office of the DPP, apart from the fact that there's a division that handles the issues of electoral and hate speech, we are going out there. We are going to talk about this election preparedness in terms of sensitizing the people, training the investigative agencies. Ourselves, we must train ourselves. We are also going to ensure that we have the collaborative approach. That is something which we are going to see from morning to evening. If we don't have that approach, then we are not going to. So if also public have something to tell us, even if it's in confidence, please we are encouraging them to talk to us. There are things maybe they might fear talking to the investigative agencies. I think as an office we have gone out there and we have given ourselves quite a good name, and we have been able to process even complaints which have been brought to us, even if we are not the investigative agencies, and we have been able to assist. So the office of the DPP will ensure that we are talking about this. We will continue educating, particularly the public. Let them know what is expected of them. They cannot also sit back and expect the investigative agencies to do. They should go out there and listen. What is that? What are those things which are talked by the community, even in a subtle way, or in secrecy? These things they should find a space. And the office will be in a position to provide an ear through even communications. We'll be having phones, we'll be having toll numbers, which the public, again, will be able to communicate. They reach out. So I can say we are prepared to the extent that everybody, especially the focal points, have been trained. They know what to look out for. And if there is somebody who has a doubt on how to manage a file, they know that they should be able to. And they, even at the county level, all prosecutors know that if they receive a complaint and they have a difficulty in processing it, then there is also the command center, which is within the office of the DPP in Nairobi, which will be able to process and quickly advise the teams on the ground.
Looks like you'll be working around the clock.
Oh yes, I can assure you we'll be working in a schedule. That people will be working maybe during the day. We can even have people working in schedules of 4 hours, so that people don't get exhausted and we are alert. And we'll be having, this has been done. We did it the last election and it worked for us. Yes, people were working in the boardrooms at night, and maybe they take over, somebody else comes and replaces them, and they can also takes over, and we are able to.
What does that mean? They just wait for information that is streaming in?
Yes.
And acting upon it.
Acting upon it immediately. So this is something which we are going to do immediately.
All right.
Yes.
Oh wow, that's interesting. Yes. We can never go away without talking about the decision to charge, the most important role of the prosecutor. So what do you look for as you make the decision to charge in electoral offences, especially evidence, because I think it's the most contentious bit?
Yes. First and foremost, let us just say we are going to look at a file. We must have the initial report. We must have the statements from the witnesses. We must have
memos.
We have to have exhibit memos. We have to have especially forensic evidence, because some of these things are.
What does that mean?
Forensic evidence.
For example, if in case of electronic evidence, electronic evidence, you need a report from the
expert.
Yes.
Who is the expert now?
When we are talking about evidence which has been received from, let's say, a telephone, somebody was videotaping. There will be a cybercrime expert who will look at evidence, look at it in wholesome. How was it said? Then they are going to put it in a transcribed way for it to be understood by the court and even the prosecutor. And that evidence is easy. It's not just putting a video there and let it run. It has to be found to be, is it a true copy? Is it?
So you must have my phone. The original phone.
The phone has to be presented. It's part of the exhibit. So this is how it must be processed, and and the person who processes it must have a certificate to ensure that it was properly done. There was no, we have been having people photoshopping or adding things on this. It will have to be the true copy, and he has processed it, and it's transcribed to a language which we can understand.
Doesn't that take long?
No. We have the experts. Actually, they have the investigative agencies, even the DCI.
So these ones are at the investigative agency level?
Yes.
Okay.
Yes. So we have to get those reports. Those reports must be part of the file that is presented to the office of the DPP. And also we must have a statement from the suspect himself. We must understand what did we have this case, we believe you have committed an offense, but we must hear from him. That way you are able to verify his evidence or what he has said. Is it palatable to mean that you can be able to verify? Is it what he's saying, is it truthful, or is it something which can be believed? Because it's not one side. You have to look at both sides. As much as you want to imagine that it's that side of the witnesses, he has something to say or she has something to say.
But they'll still come and say, oh, I didn't mean that. It was just in the heat of the moment. I'm sorry.
You will look at it in the context, because they'll come out there in the public, in media to even apologize. Apologize that some of those apologies are not true. When people are not real, the people are already fighting the ground. So we have to look at even how does it impact? How does it impact the community? So when we are saying we are looking at, when we are making a decision to charge, you have to look at the evidence. How is this evidence? Is this evidence something which is going to be admissible? Is it going to be credible in court? Is it relevant? Or is it going to be available? Is it going to be reliable? Because you can say, I have the evidence, you look at it, then you find the witness has disappeared. Now, that evidence is not available. All those rules of evidence must come to play, each and every bit of it. So by the time you make a decision, all those things must be looked at. And evidence. And the public should know that what is evidence. Evidence is not the videos running on Twitter or Facebook.
What is evidence?
Evidence is what I've explained. It is the real thing, the witness statements, what are the people saying? Those people who were in the crowd, what did they say? The police officers, for instance, if they had been in the ground, they took the videos, they took even the audios. these audios, it's what has been heard, but it also has to be transcribed in a language can be understood by the court. The court, you know, is blind. Don't assume that the court should know, heard it. Don't assume it's, the public should know that the court was not busy listening to videos which are on Twitter.
So
it is what is presented to them in court. It must be, as we are saying, it is admissible, credible, reliable, and relevant. Yes.
Wow. Can I be an anonymous witness because of my security, for example? Can I just even give you my phone, have it, do whatever it is, but I want to be anonymous because I don't want to be in the public face giving witness against a powerful person? Can I be anonymous?
Thank you very much. You are addressing the issues of witnesses, the concerns of witnesses and their interests, which is a very, very important element in the criminal justice process. Without witnesses, we don't have we need witnesses. They come to court to provide direct evidence, and they are very, very important in a criminal trial process. So especially election offenses and election-related cases and hate speech, these are cases with a lot of public interest, and therefore they predispose the witnesses to sometimes threats. So we have a legal regime to protect witnesses under the Witness Protection Act, and therefore there are measures which can be put in place to ensure that witnesses are properly protected. So one of the measures to protect witnesses is to have them testify either in camera, so that they don't come face to face with the accused persons. Yes, there are measures which can be put in place. So the accused person will not know it is me? There are measures which can be put in place to hide the identity of the witness without compromising the right to fair trial of the accused person. Because the accused person has the right to... They may demand to want to see to cross-examine, even to cross-examine the witness in court. So without compromising that right of fair trial to the accused, we also need to take measures to protect these witnesses under the Witness Protection Act. So measures can be put in place. One of those measures is having the witness testify in camera, and other measures include translocation of the witnesses, changing their identities. We have a witness protection agency, which is established by legislation to assess the threats against witnesses and to put in place measures. So we can approach the Witness Protection Agency. We can also make applications to the court so that the court can also initiate measures to protect these witnesses. Some of these measures also include denying the accused person bail if he is likely to interfere with the witnesses. So witnesses need not to worry when it comes to testifying in election-related offenses. The Office of the DPP will do everything it can within its power to ensure that our witnesses are well protected.
Yeah, I think we really need to talk about that a lot.
Just to give a lot of support to what Mark has said, I can confirm that I've handled cases, so many cases, where the witness is not known. Even myself, I might not even know when the witness is being brought from. But that witness, when he's testifying, he works under a pseudonym. He's not even known. And we make applications to ensure that that witness is never known. And there are those protection boxes. They come dressed and they are protected. You can't know who is testifying. And we must clearly tell the court, this witness, if we dared and fail, we will actually be putting this person in a big problem. So I have had cases where the witnesses have testified and no one knows them, and I can even tell you personally, I don't even know where they are staying. So if I don't know and I'm the prosecutor, they are well protected. Yes,
I think it's something we need to talk about quite a lot, because it could be one of the fears that the public harbors about reporting such cases, because who dare goes against political powers, you know? So there's something about an investigation file, and before that, we still look at the decision to charge. What does public interest mean again in this setting of hate speech and electoral? Public, does it mean what I want you to? What does public? Because I'm imagining hate speech on its own, even without defining it or anything, is already in public interest. Or does it have any other definition?
Madam defined hate speech very well. She talked about Article 33 of the Constitution, and she said there is a limit to freedom of expression. It's not an absolute right, like those rights under Article 24. This right has a limit under the International Covenant on Civil and Political Rights at international law. There's a limit on freedom of expression. If it amounts to hate speech, incitement to violence, warmongering, you have gone beyond the limit. It's not like criminal defamation, which is directed against a single individual. But this is something that is directed against a group of people based on their characteristics like nationality, race, or even ethnicity. So that becomes hate speech, and it affects the entire public. And therefore, there are criminal sanctions under the National Cohesion and Integration Act. Therefore, public interest is one of the considerations which a prosecution counsel must look at when making the decision to charge under the Office of the Director of Public Prosecution decision to charge guidelines. Public interest is not what the public wants. It's not what, sometimes the public wants you to do something which may not even be right. So it's not necessarily what the public wants. But in the legal parlance, or in the legal context, public interest is that which is good for the common good of the public, not necessarily what they want. So you should not act because the public wants you to act. A prosecution counsel should be independent. The Constitution under Article 157 established the office of the DPP, and it's a very independent office. You should not act under the influence of someone. When you make your decision to charge, it should be based on law, like Madam has explained, not because the public are pushing you to prosecute somebody and there is no evidence to even prosecute that person. So we should explain to the person the processes that Madam has explained, the investigation file, minimum requirements. Yes.
Sorry. Yeah.
There must be minimum requirements in an investigation file. The evidence must be there. It must be admissible. It must be relevant. It must be reliable. It must be available. So if the evidence is not there and the public is asking you to prosecute someone, you should not just act.
So even if I post the video and say, here's my evidence, you still have to go back to the
rules of evidence under the Evidence Act. Yes, the video must be available. There must be a certificate by the person who extracted the video. So these are requirements by law, actually. We are required by law to give a certificate to the video being, you know, it can be photoshopped. It can be photoshopped. And we have become experts. Yes.
And maybe to just add on the public interest, you have to look at some various factors. One, what is the impact it has on the public themselves? And you also have to look at who is this person, who is the suspect, what is the age of the person, it could be a very, very old person, it could be a child. You have to look at some of these things. How
does it matter?
It matters when you're looking at it in the context, because in the full context, because when you're looking at that, you're also looking at what impact will it make on the community itself, and also you're going to look at this situation. What other avenues might we look at? Might that offense be proportionate to the offense which we might want to charge? What are other ways of dealing with it? For instance, if you look at our other policies may want to do a diversion, but with some sort of rules which must be dealt with. We might look at other things which are so important to this case. So when you're looking at the public interest, yes, we have the evidence. We are sure that this is the right way to go. But look at other things, not what the public wants, but what is the best interest for the public.
Lakini from a pedestrian point of view, from just an Anita's point of view, hate speech is already so grievous that it should just be in public interest, whichever way you look at it. And maybe if we did that, if we looked at it like from my perspective, then we will not be so lenient on people who spread hate, and then they will not do it, you know. But it feels like, and when you hear people talk about hate speech and how we handle it as a country, we are too soft on it. And I don't know what your opinion is. Are the legal frameworks enough to deal with hate speech in this country?
Yes.
They are.
We don't need any other law.
Okay.
The law as it stands is sufficient.
Yeah.
It's to ensure that we work together and
Yes.
get the proper evidence. And it's true right now, the situation is very, we might, I can't say volatile, but we have to be cautious that if somebody goes out there and says something,
Yeah.
right now you cannot say that it's not for the best interest of the public. Right now, the best interest of the public might be to prosecute,
Yes.
so that we stop this kind of utterances
Yes.
or people going out there and threatening people.
Yeah.
And you know, if some of these utterances fall short of ethnic kind of isolation.
Yes.
So we have to be very careful. So the situation is ripe. But again, we are saying that as much as it's ripe, let's make sure that the evidentiary test is met, properly met. Then we can look at the public interest. And of course, the public interest now is to ensure that we are protecting the public.
Yes.
Sure.
So that
And
the
that is
best
actually what ODPP ought to do.
Yes.
Protect us.
Yes.
You are our ministers for justice, and we're only looking up to you for protection.
Of course.
Yeah. So are you ever seeing a day when we will have an election that is free of hate speech? And what is the role of the citizen, actually, as we close? What's the role of the citizen in actually curbing hate speech?
I believe by what we are doing,
Yeah.
and we are going to do it so vigorously, with so much purpose, that people go out there and know that when we are having these prosecutions, of course after the evidence is properly collected,
Yeah.
they know that if you dared say such words, whether you're saying them on Facebook, Twitter,
Yeah.
in that space,
Yes.
or you're saying it in a public place, just know that we are going to talk to witnesses. We are going to get witnesses out there. Even those ones were in the public, you thought were not going to talk. We are going to ensure the fact that we are now, all the agencies, the principals are so much committed. The commitment is real.
Yeah.
So there is no doubt that we are going to be speaking to the voice.
Yes.
We are going to be the voice of the people.
Yes.
We are going to tell people, you are not going to out there, you are not going to intimidate people and tell them things that they are not allowed in such
Yes.
an area.
Yes.
And I think if we go ahead and go with this approach of together, we are going to have we are going to have a formidable front.
Yeah.
I think people will stop inciting people out there in public.
Yeah.
Yes.
Okay.
Yeah,
I
just to
think-
add on what Madam
Yes.
has said,
Yes.
my learned friend Steve Ogola, when he was here at one point, I want to quote him, he said, every man has a residual capacity for violence. So man is by nature
Inherently evil.
okay, I wouldn't want to say that, but there's a destructive nature to man.
Yeah.
So laws exist for that purpose, to protect us
Okay.
from that destructive nature.
Yeah.
So elections are by nature very divisive.
Okay.
So hate speech is not just a Kenyan problem.
Okay.
This is a global problem. And that's why we even have a United Nations plan to combat hate speech at the global level.
There is.
There is a United
I
Nations.
think this then as a very personal problem. It is value. It's just people just going against.
Yeah,
who
it's
they
a
are.
global issue.
Yeah.
In Europe, they have issues of racism.
It's still hate
It's still
speech.
hate speech.
Yeah.
So it's a global phenomenon.
Yeah.
It's not limited just to Kenya. Elections are very divisive. You saw in the United States, Trump versus Biden, very divisive elections everywhere because of the high stakes involved in getting into political office. So you expect such things to happen. That's why institutions exist. That's why laws exist. So like Madam has said, and I support her, if it happens, we are there, we are ready, we are on the lookout. We will identify, we will direct investigations, and those found culpable. The DPP has never shied away from making a decision to charge.
Yeah.
So anybody who does that, it doesn't matter which political party you come from, we are impartial. We'll only look at the evidence.
Yeah.
And we also urge our stakeholders to do the same, to be impartial at this time, to look at the evidence without looking at other considerations.
Yeah.
Just look at the evidence, look at the facts, bring the file to us with the proper evidence. And the DPP has never shied away from making that decision to charge. Yes.
Do you have plea bargain in election offences?
Yes.
Okay.
It has been done, but cautiously.
All right.
We must, yes, you are plea bargaining, but not when it is really at a point where also the public is incited. You have to be cautious also. And if it's done, it has to be done in such a way that, especially in such with such kind of offenses, even a public announcement that you are apologizing to the public, and you take the responsibility, and you make all efforts to ensure that you are going to bring the people together. That can be one of the considerations. It's not removed from the table, but you also have to balance and know, when are you doing it? Is it for the public interest at that point? So you have to know. Yeah, it's something which can be looked at, but not, you have to look at it globally. What is the best interest of the public at that point?
Diversion, same?
Yes, it can also be done, because, again, looking at the context. When I talked about where prosecution is not the best approach, you might want to do the diversion. Again, what are you going to do? You as the suspect, you must own up. You can't just say that, when we are dealing with diversion and plea bargain, we have the evidence. So you're not going to tell us that you didn't do it. We know, we are presenting you. So it has to be done in that context to ensure that the public is happy also, and understands that we are doing it for their interests, and not for the interest of those individuals, the suspects. It is for the interest of the public, and then you can get a very positive engagement or appreciation from the public that it was for their best interest.
These are alternative justice systems, plea bargain and diversion, and IEBC is already doing it when they fine people. They explained last week, someone was here on set, Mr. Crispin Owie, the legal director at IEBC. He explained that they are fining people. So I think that is, they are dealing with offenses using other alternatives. It saves court time, because bringing all those cases in court, sometimes you can actually make it very difficult for the justice system to operate.
Congested.
True. So you are talking about bail.
Bail and bond, are you allowed? Is it allowed in
bail is a constitutional right.
With conditions.
Yes, there are, but there are instances where that right to bail can be deferred, or the court can refuse to grant bail under some circumstances, where compelling circumstances. For the litigation officer, winging file to a prosecution counsel, where compelling circumstances exist, a flight risk, or if he poses any danger to the witnesses. If there are any compelling circumstances, let the investigation officer bring an affidavit, let him inform the prosecution counsel at the earliest, so that when plea is being taken in court, the prosecution counsel can now make that application to have the bail or bond deferred. Yes, because of the compelling grounds.
Something I think we should also explain to the public is when, before the case goes to court, there's always that application of mtu ashikiliwe mpaka investigations ziishe. There's that duration. What does that mean? Is it that the evidence is not enough, or is it to be?
But
you are a working constitution.
But the suspect has a right to be informed the reason for continued detention, and it's not automatically granted by the court. The prosecution must satisfy the court why this suspect has to be remanded in custody pending investigations. For example, if he is allowed to roam there freely, maybe he's a flight risk, he might escape, he might interfere with the witnesses, he might interfere with records which you want to rely on in court. So you need to hold him in custody. So holding him in custody does not mean that you are taking him somewhere in Boni Forest to torture him, to hurt him. No. Custody, you are holding him in lawful custody. It's not a Kamata Friday kind of mentality people think about. It's necessary. It's a legal requirement under the Constitution. It's a mechanism to allow the prosecution and the state to finish their investigation, because we are required to present a suspect in court within 24 hours. And sometimes it's not possible for the investigators to conclude their investigations within that very short period. So they can come in under that provision to seek for extended must satisfy the court. The court will not grant it automatically.
Okay.
Yes.
All right. Okay, so there's some comments on Facebook as we wind up. We've done an hour. It keeps just runs out so fast.
Very fast.
Yeah. So Mukhana Mukabras is watching from Canada. Thank you, ODPP, for coming live to educate us. And then he asks, how do I verify from your office that they received a letter from DCI Nairobi? I don't know whether that is within what we're discussing, but maybe just as a response, how do I verify from your office that they have received a letter from DCI Nairobi?
Oh, meaning maybe a clarification. The letter was sent to the DCI.
The DCI
Yes.
sent a letter to ODPP concerning something.
All right.
He doesn't say what. How do I verify from your office that they received a letter from DCI Nairobi?
Maybe she can reach out to us.
Yes.
We have a website.
Yeah.
And in that website, www.odpp.go.ke, she can be able to see our contacts for all our regional offices, include office in. She can call us. She can send an email, give us the particulars, so that we can be able to follow up on your complaint and verify whether it has been addressed.
Okay, and in this time and age, you can slide kwa DM.
Yes, you can even, Twitter, Facebook.
Yeah, you'll get. So Norma Corey says awesome conversations. Sam Karaoke was I hope you got the sound and the pic, Sam and Charles. And then on YouTube, Angela says, one can never be too prepared. Good job, ODPP, for focusing on this topic. And then Donaldson Robin says, good job, ODPP. So I think the conversation is slowly gaining momentum, and we just need to keep talking about it.
Very true.
Yes, and I think even as we go closer to the...
It's a wide
It's
topic,
quite wide,
very wide.
and we need to keep reminding, like you said, to remind the public they have a role to play, and they are protected within the law should they come out as witnesses and all that.
Yes.
Yeah, and of course that ODPP is apolitical.
Very.
Completely. We are impartial.
Yes.
Yeah, we are actually blind, as they say.
Yeah.
We are going to do everything to ensure that we provide justice to all Kenyans from all fronts.
Okay. Yeah. I like that thing of we are the ministers for justice. So sisi tuko tu nyuma yenu, tumejificha nyuma yenu.
Kabisa.
Kazi yenu ni kutu protect.
Kabisa.
Yeah. So ladies and gentlemen, we've come to an end of the show, and I'm glad that you've been with us. Thank you for engaging us. Keep engaging. We'll get some responses as we go along. In case you have something you want to ask in private, slide kwa DM. If not, then on the ODPP website, you'll get the contacts for the different offices in Kenya, and of course, help desk here at ODPP. Reach out and get to ask whatever it is you want to ask, and you definitely get a response. So hate speech is quite a subject that cannot be exhausted, especially in this country. We have seen the effect, the impact of not dealing with it, and of course, the result of dealing with it. And one of the ways of dealing with it is having these conversations. And I'm glad you're having them now. We'll keep having them as the months, as we get closer to the election date. And of course, there's a call to action to all of us as citizens to participate in curbing hate speech. You are called upon, I am called upon. The ODPP are the ministers for justice. They are doing their bit, so you can also assist. And of course, Madam talked about the criminal justice system. It doesn't change. The mandates are the same. Only that this in the electoral space now we have NCIC and ESCC and IEBC.
Even
ESCC as one of the investigative agencies. You can reach out to them should you have a complaint. You've heard about evidence. You've heard about public interest. It's not exactly what you and I think should take place. There's so much they look at when it comes to public interest and in evidence. So there's so much conversation that you can have around hate speech, and we'll keep having it. We welcome you to also suggest to us what you want to talk about, what you want the ODPP to address in as far as electoral offenses is concerned. The law is clear. Our role is also quite clear. We need to do something about how we want to be governed and how we want our elections to happen. And like we said, what Steve Ogola said the last time, let's try and make our elections. We need to look forward to elections like we're looking forward to Christmas. And it's possible, based on Mwalimu Maki and Madam Jacinta's confidence in our systems. So thank you so much for today. We welcome you again next week to see what we'll be talking about. Keep following, keep engaging, and we'll definitely engage with you. I want to wish you a good Friday and a good weekend ahead, and of course a productive week starting Monday. Have a nice day today. Thank you so much. God bless.
Thank you.
Thank you.
All right. Thank you, sir.
Thank you so much.